you who don't know me, my name is Charles Livingston. I'm a partner in the Government Regulation and Competition team here at Brodie's, and I'm going to be chairing the first half of the conference. Just like to start by welcoming everybody in the room. Thanks for coming along. Hope you will have a good time with us and find the session very interesting. I'd also like to welcome those joining us by live stream from the more remote councils who are less able to make it to us. Just a little bit of housekeeping for the live stream. We are intending to have that throughout the session with the exception of the Q&A session following Paula McLeay's talk on the Transient Visitor Levy for Edinburgh Council. Reason for that is a slightly politically sensitive topic, so just to facilitate discussion in the room, the live stream will drop off for that. The running order for today is we're going to start with duty of care with Neil McLean and Kate Donaghy, who I will introduce in a second. We then have a slight change to the advertised running order, so it will then be Paula McLeay of Edinburgh Council at that point. So the live stream will drop off at maybe around 11:15, something like that, for the Q&A session. And the live stream will then resume at 11:15 after the coffee break here, at which point we will have Sandra MacDonald with an update on adults with incapacity, and then to close off we'll have Brodie's own Nichols on ALEOs. There is no fire drill expected for today. So if the building starts to talk to you, it will tell you what to do, either to prepare to leave the building or actually leave the building, depending on where it thinks there is a fire. So you will be left in no doubt what to do. The fire exit is over in the corner to the left of reception as you look at it. So I think that's all of our housekeeping. So without further ado, going to introduce our first session. As I said, that will be on duty of care, and that will be delivered by Neil McLean and Kate Donaghy, who are both managing associates at Brodie's. Neil is in the Government Regulation and Competition division, and Kate is in our Insurance and Risk division. And I think Neil is going to kick off. Neil.
Thank you, Charles. I'd like to welcome everybody here today. I'd also like to welcome those watching on the live stream. And it caused me to reflect on the last time I appeared on live television. The year was 1988. I appeared briefly on a kids' television show called Get Fresh. I was in the background of a shot as Gilbert the Alien introduced the reggae band Aswad, probably the first and only time Aswad ever went to Stranraer. Later that day, against my parents' advice, I ate an entire Victoria sponge. So I'm hoping for a similar result today. Indeed. So on today's menu, we have a refresher on some common law and some statutory duties. I'm going to look and remind you on the common types of claims that local authorities might face. But really, the real purpose of today is for what Kate is going to say about vicarious liability and the changes to the law there, because that's why we decided to run this session. We thought about areas of the law that we hadn't spoken about at a conference for a while, where there had been some changes, and it might be helpful just to refresh everybody's thinking on it. And alongside that, we're going to look at some procedural changes that have taken place that will impact in the way in local authorities defend claims. So today we're principally talking about civil liability. So local authorities are obviously subject to a wide array of statutory obligations, and we're not going to focus on breaches of those statutory duties. And what we're talking about here are claims for damages where local authorities could face a claim for financial compensation where they owe a duty of care to a person and it's alleged that they breached that duty of care. I'm going to look at some common types of claim in a minute, but clearly civil liability has consequences for councils. You may have to settle claims, including out of your own funds. And we know that local authority clients are still trying to find budget savings in a number of areas. So anything that depletes the council's resources is bad news. There's also ancillary costs to the council. There is the staff time and resources spent dealing with claims, including managing your elected members, which can be challenging in the face of litigation. and there's likely to be some publicity, particularly if there has been a finding of fault on the council. And again, that brings you into that careful management of your elected members and their reaction to what the press have to say about any finding of fault. So just a reminder of some of the common law duties. And these are the tests for negligence. So a local authority, generally speaking, has a duty to take reasonable care for health, safety and well-being of employees and non-employees relevant to civil claims for damages. That duty to take reasonable care is often referred to as the ordinary standard of care. If there is a question of professional negligence, then a different test applies, and that's the steps and you could be in a local authority, potentially a teacher or a surveyor if you employ any, of ordinary skill would have taken if acting with ordinary care. And as you would expect in a lot of cases involving negligence, there's an argument about which of these duties applies. Is it the duty to take reasonable care, which is a lower standard, or is it the duty in respect to professional negligence, which is a higher hurdle for pursuers to get over? And we see that a lot in cases that we advise local authorities in. Just some procedural points then, and I'm not going to spend too long talking about this because Kate's going to cover the changes in the law. Of course, the onus is on the pursuer to establish liability in the balance of probabilities. With personal injury claims, there is a 3-year time limit generally, although Kate's going to talk about the changes to that, particularly in relation to abuse claims. And generally with other claims, there'll be a 5-year time limit. We now have the Prescription Scotland. I think it is still a bill. Our professional support lawyer pointed that out today. You're not technically allowed to call it an act yet, but it has been passed, which amends the Prescription in Scotland Act 1973, makes changes to the law of prescription. That is probably a session on its own, so I'm not intending to say very much about it or anything about it at all, and Kate isn't either. So some common types of claim then. So these will all be familiar to you. Councils can face claims for slips and trips. Normally they'll be dealt with under the ordinary standard of care that I referred to a moment ago. A very sore one for the public, potholes, a lot of claims about potholes, and that's because the Council as a roads authority has a duty of care towards road users at common law to ensure that the roads are maintained. You might face claims under employer's liability. I said we were going to talk a bit about statutory duties. Well, all the Employer's Liability Scotland Act does is create a statutory duty of care, so it gets over that first hurdle of negligence and allows for an action where a council is an occupier of a premises and fails to take such care as in all the circumstances is reasonable to see that a person will not suffer injury or damage. Kate's going to cover abuse claims in a bit more detail, but I find the claims involving schools quite interesting. It is competent to bring an action for negligence arising out of bullying, and we've seen attempts by pursuers to bring actions on that basis, alleging that individual teachers have been negligent. And one of the arguments that's often run is that a teacher has been negligent because they haven't acted in the manner expected of a reasonable parent and have failed to take all reasonable steps to prevent bullying. But what the court has said is actually it's no different to any other action for professional negligence, and what you're looking at here is the steps a teacher of ordinary skill would have taken if acting with ordinary care. There are also personal injury claims that arise out of school, some fairly nasty ones as well. And what, again, you're looking at there, where it's a personal injury claim, you're looking at reasonable care for the safety and health of pupils and looking to exercise that duty of care with regard to the age, inexperience, carelessness and high spirits that you might see with school children. Finally, just on the types of claim, I was calling this the Brodie's Wheel of Fortune, but it's probably the Wheel of Misfortune. So obviously local authorities are subject to a wide variety of duties. And if there is an incident, of course you might face a claim for negligence, but you have to think about all of these other things too. So there might be a contractual claim brought alongside it. if it's infringed anybody's right to property or their right to private life, you might see a human rights claim, a claim for just satisfaction under the Human Rights Act. Often when you see a human rights claim brought alongside it is a claim under the Equality Act. They often go hand in hand together. If it's a very serious incident, there might be criminal charges, and if it's a fatal accident, there might be a fatal accident inquiry. When all those things round the wheel happen, you're definitely going to have media interest, you're definitely going to have some human resources issues, and you're probably going to have to conduct an internal investigation. So that's why it's always important to think about the duties that you owe and how you're going to respond to them when something happens. I'm now going to pass to Kate, who's going to talk about vicarious liability.
So hello, and thank you for coming along. I'm going to talk to you today about vicarious liability. It's an area of law that's changed quite significantly, and in which we anticipate there will be more change. But why is it relevant to local government? What vicarious liability is responsibility for something that someone else does. And really the risk arises where an organisation facilitates contact between individuals, and that risk is heightened where the contact is with people from vulnerable groups. And so given the range of responsibilities that local authorities have, this is a risk that arises in the operation of local authority business. And it's key that the risks are understood and that the relevant steps, where you can take them to protect local authorities, are taken. So I think it's really important that you understand what's happened here and what the implications are and what can perhaps be done to safeguard against some of those risks. Now, I'm going to run through a brief summary of what I'm going to talk about today. I don't think we can really talk about the changes and understand them unless we really understand what the doctrine is and why we have it. The main change here has been brought about by 3 very important Supreme Court cases, so I'll have a look at those, then have a look at what's happened since then and anything we can draw from those developments. And I'm going to look, as Neil said, at some legislation in Scotland which is likely to interact with these changes and make them particularly difficult, I think, for local authorities to manage. So what is vicarious liability? It's a common law principle of strict no-fault liability. It's fairly harsh in its operation. You're going to be liable for something someone else has done, even if you have done nothing wrong, even if the wrong is unknown to you, unauthorised by you, and adverse to your interests, and even if you told the person who does this thing not to do it. Now, it's important to note at this stage that it's civil liability. You're not going to be criminally liable for something someone does, but you can be sued in your own name. So it would be the local authority that's facing the civil claim, and it's the local authority that would get the publicity of that. So it is very significant. So this is a very harsh doctrine. Why do we have it? Well, broadly, context is 1700, where it was said, seeing that someone must be a loser by this deceit, it's more reasonable that he that employs and puts trust and confidence in the deceiver should be the loser than the stranger. And more recently, Lord Brougham in 1839 said, the reason I am liable is this, that by employing him I put the whole thing in motion, and what he does being done for my benefit and under my direction, I am responsible for the consequences of him doing it. Now, the modern exposition is Lord Nichols in Madrowski against Guy's and St Thomas NHS Trust. And he said there, all forms of economic activity carry a risk of harm to others, and fairness requires that those responsible for such activities should be liable to persons suffering loss from wrongs created in the conduct of those business, of that the enterprise. Which, those cases span 300 years, a little bit more than that, but the message is really the same. If you have an enterprise and you're doing something and you create a risk because of that, it's you who should bear the blame if something goes wrong, even if it's another individual who does something you tell them not to do, who does it. So that's the underlying principled justification for this doctrine. But the traditional formulation really reflected a traditional view of what employment was. So I've got a horse and cart there, but the early cases focused on a master and servant relationship, where an employer really exercised a lot of control and oversight over what their employees did. Now, there were two requirements: a relationship of employer-employee, and that relationship was, as I've just said, very traditional, where the employer exercised a lot of control. The second requirement was that the act was committed in the course of that employment. Now, what we're going to look at today is the first thing there, a relationship. So is there a relationship between the organisation and the person that does the wrong thing so that the organisation is liable? Now, things had moved on in the 50 years leading up to these Supreme Court cases, and the court had held that an unincorporated association could be liable for the act of one or more of his members. Employer can be liable even if the act was in violation of the employee's duties. You've probably heard the phrase a frolic of their own, and that was generally thought to mean you wouldn't be vicariously liable if your employee was off on a frolic. I think that's probably been a misconception for a while, but it's persisted. An employer can be liable for sexual assault by an employee. That was a development that came about following the House of Lords case Lister against Hesley Hall in 2001. That's a relatively modern idea. And it's possible for two defenders to be liable for the same act, which does open the door to the possibility that someone who's not an employer can be vicariously liable for something that someone else does. But the three Supreme Court cases we're going to look at, go back, have significantly extended the scope of vicarious liability, and they're viewed as being incredibly significant. But they didn't come about in a vacuum. They arose in the context of heightened awareness of institutional child sex abuse and a desire really to find compensation for the victims of that abuse. There were a number of claims raised by victims against organisations where they couldn't sue the actual abuser for whatever reason. And those cases foundered on an application of vicarious liability along the traditional lines. But there were also other problems with vicarious liability because in the 300 years since it made its way into the modern law, we've changed the way we work. We've changed the way we interact with our employers. We're not controlled to the same extent, and there's probably far less oversight of what people do. So the law didn't reflect the modern reality of how things operate. So the first case, the Catholic Welfare Society and others against the Christian Brothers, which we tend to refer to as the Christian Brothers case for obvious reasons, it came about because children who'd been educated in a religious school wanted to sue the school because they'd been abused by the Christian Brothers who taught in the school. But the Christian Brothers weren't employed by the school. They had quite an unusual arrangement, and it was held in lower courts that vicarious liability couldn't apply because they didn't satisfy this relationship of employment or akin to employment. So it came before the Supreme Court, and Lord Phillips gave the leading judgment. Now, this was an overt attempt, reflecting everything that was going on in the lower courts, everything that's happening in the press, and just generally to clarify the law here, and really, I think, a desire to find compensation for people where they couldn't under the current application of the law. And what Lord Phillips tried to do was distill down the principal justification for vicarious liability. Why are employers vicariously liable for their employees? And he says the policy objective underlying vicarious liability is to ensure, insofar as fair, just and reasonable, that liability for wrong is borne by a defendant with the means to compensate the victim. Now, hold on to that thought, because that's quite significant. But he found 5 features of an employment relationship which he said justified holding employers vicariously liable for what their employees did. And what he said was, these 5 features aren't unique to employee and employer relations. You'll find them in other relationships. And if you do, it will be fair, just and reasonable to find that person vicariously liable for something someone else does. Now, the 5 things he found were employers more likely to have the means to compensate, back to that. The wrong was committed as a result of activity by the employee on behalf of the employer. the activity is likely to be part of the employer's business activity, the employer has created the risk of the wrong, and the employee will have been, to a greater or lesser extent, under the control of the employer. The next case which got to the Supreme Court was Cox against the Ministry of Justice, and Cox was a prison officer who was injured when a prisoner bashed into her in a prison kitchen. She said the Ministry of Justice were vicariously liable for the prisoner's actions, and when the case first came to court, she failed. It was held that the prisoner wasn't employed by the prison because, although we might think there were features similar to employment, we actually weren't under the same level of control as a prisoner was. They didn't have any choice but to be in the prison, and they really didn't have any choice but to do this work. The Court of Appeal disagreed, and the case came to the Supreme Court, where Lord Reid gave the leading judgment. Now, this is another important point. Whether it should be applied does not depend on the classification that's given to the relationship. So it doesn't matter what you call it, it doesn't matter what it is called. The court is going to look at the reality of what's going on here. Now, he accepted the 5 principles, but he refined them. They're not all of equal importance. He also confirmed the underlying policy for vicarious liability, which is that where someone does something when they're furthering, when you're involved in someone's business activities, whether you're furthering them or not, you should be liable for the wrong that they do. Now, for local authorities, the important point to note here is the business activities need not be commercially motivated. So we're not looking at big bad corporates, we're looking at anything that operates in the business sphere. And the defender's ability to pay the claim is not of significant importance. And he said, wealth and insurance are not a principal justification for imposing liability. Well, maybe not, but there's quite a compelling practical reason for finding someone liable if they're able to pay. And obviously Lord Phillips recognised that. So I think that's very nice, but I'm not sure that follows through, even in the cases we've had since this. So he looked at the 5 criteria set out by Lord Phillips, and he said that the most important ones are: it was committed as a result of activity on behalf of the employer, it was part of the business activity, and the employer has created the risk of the wrong. So we're just right back to the concepts we discussed at the start. Lord Brougham in 1839, I've set the whole thing in motion by employing him, and it's right that I should bear the loss if something goes wrong. And also Madrowski, where economic activity carries a risk, and fairness requires that those responsible for creating that risk bear the cost if it goes wrong. Now, it's important to note that Cox wasn't a case about sexual abuse, but there is this context, and Lord Reid was clear to say these principles apply to all areas in which vicarious liability can arise. They're not restricted to cases of abuse. He also said vicarious liability is not going to arise where the wrongdoer has a recognisably independent business of his own. And that probably starts to make people think of independent contractors. And it's long been thought that if you're an independent contractor, someone can't be vicariously liable for something that you do. But that's not right, and we'll come to that. So that brings us to arms. Now, this is the case that really set the hair running, I think, and made people realise where this new interpretation of vicarious liability could take us. The Christian Brothers case was about essentially teachers, the school being liable for teachers, Cox about a prison service, Ministry of Justice being liable for prisoners who were essentially working in the prison. But arms was raised by a person who had been abused while she was in foster care. And she said the local authority were vicariously liable for what happened to her in those homes. Now, she didn't say that the local authority had been negligent in choosing, vetting, or supervising the foster carers. She simply said, you're vicariously liable for things they do that are wrong. Now, initially, when this case first came to court, it was held that the local authority just didn't have enough control, and nor should it, over what happened in the foster carers' homes to be vicariously liable. But Lord Reid, again, in the Supreme Court, gave the leading judgment, and he said the local authority were liable for what the foster carers had done. They were carrying out this activity on behalf of the local authority. The only reason they had this child under their care was because the local authority had a duty to care for her or to find care for her. So they had created the risk and the need for her to be placed in that home. Foster carers weren't carrying on a business of their own, they were just working for the local authority. And there was sufficient control of the foster carers. The local authority had oversight of what they were doing, and the foster carers had to ask for permission to do certain things or make certain decisions. And the local authority had the means to pay the claim, which brings us back to that point. Now, it was suggested this might discourage local authorities from placing children in foster care, but I think Lord Reid recognised the practical reality, which is there aren't really many other options, and placing children in institutional homes, as we know.
That's gone so well, hasn't it?
Yeah, so I think he recognised that actually there is no choice really for local authorities, so they won't stop using foster carers, but they will be liable if a foster carer does something wrong in a situation where the local authority has very little control over what goes on in those homes. And what Lord Reid said was, the most influential idea in modern times is it's just that an enterprise which takes the benefit of activities, so in this case local authority, benefiting from these children being cared for, should bear the cost of harm where it's caused by someone in the course of those activities. So those three cases are really a journey which ends with us looking at the possibility of an organisation being liable when something goes wrong in the course of its operations, whether the person that commits that wrong is employed by them or under any real degree of control. So those were all English cases, and ARMS was decided back in 2017. So what can we glean from what's happened since then? Well, we have one Scottish case, and it's Grubb against Shannon, and this is a Sheriff Court case, so it's not the most authoritative of decisions, but Sheriff Reid gave a very detailed decision in this case, and he looked at all of the authority and roundly agreed with the three Supreme Court cases. So it would indicate that we're going to follow in the footsteps of England in this. Grubb was about a beauty therapist who injured someone while she was treating them. She worked in someone else's salon, and the pursuer argued that the salon owner was vicariously liable for the beauty therapist's mistakes. Now, they had an arrangement between them where she was self-employed, she effectively rented a space. Lots of people would think she's independent business. Sheriff Reid said, well, we don't really care what you call it, we don't really care how people view this from the outside. The reality is she was integrated into the business, the defender exercised control over things like the price she charged for her services, and the defender is vicariously liable for what she does. He says you need to step back and consider the reality of the position based on the totality of the evidence. Function and substance now triumph over form, which means you can't just look at a label and take comfort from that. You have to really think about what is it that's going on. Now, have been some limits, and this is an English Court of Appeal case about bailiffs. Someone said they were assaulted when bailiffs came to their house. They sued the JBW group, who had subcontracted the collection of council tax to Mr. Boylan. Mr. Boylan had his own indemnity insurance, had paid a bond into court, which you have to do if you're operating as a bailiff in England, and was operating an independent business. And the court said that's right. He had his own business. He could have directly obtained that contract. They were effectively competitors, not in an employer-employee hierarchy. And so you could have taken some comfort from that and thought, good, you know, if we're in a traditional independent contractor situation, it's probably still going to be okay. Well, then along comes various claimants against Barclays Bank. And this is an unusual and unpleasant case raised by various people who had been employed or who'd applied to be employed by Barclays Bank through the 1980s. And at that point, Barclays Bank obliged its employees to go for medical examinations with a doctor who they'd appointed. And these people said he had sexually assaulted them. And they sued Barclays Bank. By the time they brought the claims, the doctor had died, his estate had been wound up, and there was no money to pay the claimants. So they said Barclays Bank were vicariously liable for what he did. He wasn't employed by Barclays. He had his own business. He worked for other people. He took in instructions from other organisations to look at their employees. He ran the business out of his own premises. He arranged the appointments. He carried out the examinations on his own. But what the court said was he he was doing what he was doing because Barclays Bank asked him to do it. By asking people to go for this examination, Barclays created a risk that they would be assaulted in this way. And they had some control over him. They gave him a standard form to fill in, questions he had to ask and answer. And so the bank was found liable for what he did. And the reason I put that up there is that's a bright line. And we previously thought there was a bright line rule here that if you're an independent contractor, someone is not going to be vicariously liable for what you do. Well, Barclays Bank just decisively puts a line through that. It doesn't matter if someone is an independent contractor, you might still be vicariously liable for what they do. And that's really important, and it's important to bear that in mind because that's another persisting concept along with frolic of their own that I think people have, for one reason or another, stuck in their head. So I said I would look at some legislation that's come in that is going to have an impact here. And the first piece is the Limitation Childhood Abuse Scotland Act 2017. And what this does is it removes a time limit for cases in relation to childhood abuse. So previously you would have had 3 years from when the abuse when the abuse stopped, or 3 years from when the person who was abused turned 16. But there have been many cases where people have tried to bring cases 10, 20 years after the abuse stopped and have given various reasons for not having brought the case sooner. The way Scottish law operated before this Act, they couldn't do that and they'd failed. Several people had failed. So this Act allows them to bring an action regardless of when the abuse happened and regardless of their age. There are some safeguards. They won't be allowed to proceed if it's not possible for a fair hearing to take place. The defender would be substantially prejudiced, or having regard to the pursuer's interest in the action, the prejudice is such that the action shouldn't proceed. We've not had any decisions on this yet for reasons that I'll come to in a minute, but it's likely we're going to see a focus on those safeguards. However, given that the Act has been thought necessary, it's unlikely that defenders will avoid claims in the same way they could before it was in place. So something more than was previously needed will be required. But that opens the possibility for claims which would long have been thought to be dead, can now be brought, and a whole range of risks going back as many years as people have been alive. The second piece of legislation that is relevant here is the Civil Litigation Expenses and Group Proceedings Scotland Act 2018. Now, that's significant here because the Act is an Act, but it isn't enforced yet. And when it comes into force, we're going to have qualified one-way cost shifting. What that means is if a pursuer brings a claim and fails, except for in some very particular circumstances, the pursuer is not going to be liable for the defender's expenses. So claims of historic abuse are difficult for pursuers, and they might have been put off in the past because they would think, well, I'll make this claim, and if I fail, I'm going to be liable for thousands and thousands of pounds. That's no longer the case. And solicitors who take these claims on, sometimes on a speculative basis, are more likely to bring them because the downside for them is far reduced. So we have been told by firms who are acting for pursuers in historic abuse claims where there is no time imperative, they don't need to get the claim in by a certain date, they are holding on to those claims until Quox comes in. So we know that there are cases sitting in the background that will come forward once Quox comes in. So the combination of those two pieces of litigation make these kinds of claims so much more likely, and we should all be aware of that. So,
sorry,
yeah.
I must have missed that. Is that for just sexual abuse claims and the thing about expenses?
No, that's for all personal injury actions.
Really?
Yeah,
Okay.
so it's going to have an impact across local authorities generally because, you know, I know that as local authorities you tend to face a fair amount of spurious and vexatious claims, and it's difficult enough to deal with them. But now you're going to be in a position where if you know a claim is ridiculous and you know that if you took it to court you would win, you're not actually going to win on a financial level because you're going to have to pay your lawyers to run that case for you anyway. And these concerns were all raised with the Scottish Government when they were scrutinising the bill, but they wanted access to justice, and that's why we're going to have Quox. So it's very significant. So what do we need to think about? Well, consider that in January this year, textbooks were still saying that an independent contractor was someone for whom an organisation couldn't be vicariously liable. This is a big change. It's going to take a while for people to get their heads around it. We're going to see more cases. We know that. Lord Reid said in Cox, vicarious liability remains on the move. I think we'll probably see another Supreme Court decision in the next year or so. So we need to be alive to that. And that poses difficulty when you're assessing the risk you have across your organisation. You've got the Limitation Act, which is removing the time limit. So in terms of the space of time, you've got far longer period over which you're at risk. And now you've got a far broader range of risk, because activities like foster carers, where you would have previously thought that's not our risk, it is your risk. And there will be other things that local authorities do where you have someone else carrying them out for you and you don't employ them, they're an independent business, you might be at risk for something they do wrong. Now, the vast majority of cases where vicarious liability applies will be employment or very close to employment. And as I've said throughout this talk, the idea of paying and being able to pay, despite what Lord Reid said in Cox, I think is key here. Where there is no one else to pay, the court is more likely to find you vicariously liable for something that's gone wrong. Unfortunately for local authorities, you may well be the last man standing when you're looking at historic claims, because other people and other organisations have fallen by the wayside in the time that's elapsed. So that's a real consideration as well. What I would say needs to be taken into account as well is insurance cover, because what the court is saying here is not that these people were employees, it's saying that it's fair to find you liable for what they've done, and that means that your employer's liability policy might not respond to a claim and would leave you without insurance cover. So public liability policies need to be looked at to make sure they cover you for these kinds of circumstances, and also that your indemnity limit is enough to cover the potential exposure that you have. You might also want to look at contractual indemnities from people. Now, they're only going to be any good if the person you have the indemnity with has the money to pay when the claim comes in, and the court's not going to be skewed by what you've agreed between yourselves. But it might be useful in terms of focusing people's minds about where the risk lies to think about that. A contractual indemnity won't stop you from being sued, and it won't stop the possibility of bad publicity, but it will save you from some of the financial consequences of a claim. Okay, so that is all I have to say on that today. Does anyone have any questions on that?
Yeah, just any questions or comments? I'll just bring the microphone so that the live stream can hear.
Thank you. In the Barclays case, the fact that the doctor was now deceased and his estate had been wound up, was that one of the reasons given for then pursuing Barclays?
It might have been one of the reasons given for them pursuing Barclays, but it certainly wasn't a key principled reason for finding Barclays liable when the court came to make its decision. The point is, practically speaking, they wouldn't have needed to sue Barclays if he'd been alive and able to pay. So it was a key reason that they were there, but it wasn't a justification given for the decision that was reached.
Other questions, comments, screams of terror?
Just a couple of things. I think, apart from the Supreme Court cases, the three you mentioned, also think look at Morrison supermarkets as well, because that came out similar time to Cox, and it used to be that you thought if an employee didn't do something that was it was so remote from their actual duties that the employer wasn't liable. Well, Morrison supermarkets tells you that view is wrong.
Absolutely.
And the other thing is just the sheer publicity generated by the Scottish Childhood Abuse Inquiry, even although it's not primarily there to find liability. That's the other thing to remember in terms of
it's in everyone's mind.
Down the line.
Yeah.
Let's do a quick recap of Morrison's just for those who don't know.
Yeah, so Morrison's is a Court of Appeal decision from last month, and it involved a data protection breach by a former employee of Morrison's.
It's a different
You're thinking
case.
of different. You're thinking of Morrison's
Mohammed.
description.
You're thinking of the one. It's an employee. Yeah,
Right.
that case is one.
Let's do both.
Yeah. Mohammed against Morrison's was a man who goes into a petrol station to ask for photocopying or something, I think, and then faces a barrage of abuse from the employee behind the counter. He leaves the shop and is pursued into the car park where he's assaulted. I think he later died, but I don't know if it was suggested that was due to the assault. And Morrisons were sued as being vicariously liable because it was their employee who inflicted this harm. And they said, with this idea, well, it was a frolic of his own. It certainly was not his job to go about assaulting our customers. But what the court found, and it was issued at the same time as Cox, you're right, was that he started off in his employment role and there was a continuous stream of activity from him standing behind the desk. It was the fact that he was behind that desk for Morrisons that led to his ability to meet this man and assault him, and all of that made a close enough connection to find Morrisons vicariously liable for what he did. So it's back to what I was saying at the start, that if someone sexually abuses someone, that is never their job. It's absolutely against their job when they're looking after a child, but that doesn't preclude vicarious liability. So there's a wide range of circumstances, even once you're employed, that's right.
And now the data protection case.
Yeah.
Poor old Morrison.
No, Morrison's case number 2. Yeah, so this was a data protection breach by a former employee called Andrew Skelton. What he had done is he'd released a lot of payroll data about Morrison's employees. So those employees got together and brought a claim for compensation against Morrison's for that data protection breach. And Morrison's lost in that case on vicarious liability, even though the Information Commissioner had conducted an investigation and found that Morrisons had complied with their statutory duties and also bore no criminal responsibility for his actions. So Morrisons weren't going to face any criminal sanction or any civil sanction from the ICO, but yet they could still have to pay claims for damages brought by their employees about the actions of a former employee. So it goes to show again that the court is looking quite closely at issues of vicarious liabilities and is willing to find employers liable in all sorts of different situations. And one of the things the court said in Morrison's was that the data protection risk is a risk that you could have insured against. And that was another factor that they took into consideration. Morrisons are appealing to the Supreme Court, so we may get another Supreme Court decision looking at vicarious liability before too long.
Other questions? Okay, I'll close with a slightly contentious one then. Are there any cases where courts have refused vicarious liability?
Well, the bailiffs one is the only one really of any note that's come out in the last 2 or 3 years. And you might take some significance in the fact that the bailiff who allegedly committed the assault had a bond of £10,000 paid into the local court, and had his own indemnity insurance he could pay. Because some of the observations in that case about his independent business and the way he operated it would have applied across to Barclays Bank case, but Barclays Bank were found vicariously liable. So the cynic in me would say the ability to pay may well just be the decisive factor in these cases.
Okay. All right, we will wrap up that session there. If everyone can join me in thanking Neil and Kate, and there are Neil and Kate's contact details if anyone has any other vicarious liability questions. So, now moving on to our next session on the Edinburgh Transient Visitor Levy, which has been determined in the press to be the tourist tax. To speak today, just like to introduce and welcome, very glad to have her, is Paula McLeay, who is a Senior Manager for Policy and Insight at City of Edinburgh Council, Policy Lead on the Transient Visitor Levy and the Workplace Parking Levy as part of the Council's strategic team. So, Paula.
Thank you. So from something very, very specific and immediate to something which is being discussed and negotiated and lobbied for at the present, but probably won't come in for a period of time. But it's worth looking at how we've approached in Edinburgh the Transient Visitor Levy, what we're trying to achieve, and how we might see that becoming a legal reality for the council. So I don't need this, so I'll just step here. So, the journey so far for Edinburgh. This Transient Visitor Levy has been a debate in Edinburgh for a significant amount of time. It's not a new debate, but it's certainly heated up in the last 8 months. It's also not a new debate for the EU and for other countries across the world. We are one of only 9 European countries that don't have the power to raise a TVL. And so I would say that there is a significant amount of practice in Europe that we are drawing on to look at how TVLs can be applied, what they look like, how they can be administered, what the scale and scope of them are. It's not new, and we're not the first people to do it. And I personally take quite a lot of comfort from that. In Edinburgh, the SNP and Labour coalition are committed to the introduction of a TVL, and the council has voted in support of that proposal. So as officers, our job is to take forward a proposal, a detailed scheme, and consult on it, but we do not yet have the legal power to implement it. Once we have developed what we think is a very reasonable, realistic, and operationally sentient proposal, we will be putting that to the Scottish Government and requesting that they then grant us the power to implement it. But obviously, this whole debate is now wrapped up in local government settlement negotiations, and the Green Party has been very clear in its expectations and asks around TVL in the Parliament. So we would expect some movement on this in the coming months. So this is just to give you an outline of how we've gone about TVL in the last 8 months in Edinburgh. We've had informal engagement with our stakeholders. We've also had roundtables. We've made sure we're targeting industry, culture and tourism stakeholders, but we've also been clear that this is about more than industry, and we have been approaching, through independent research, our residents and tourists to ask for their opinions and make sure that their voice is balanced in this debate as we move forward. As the council, we've also produced a research paper, which is a desk exercise looking at other research across Europe and internationally. And as I say, we've done a survey of our residents and tourists. And what we heard in that informal engagement was a significant amount, but it came down to 6 principles: fairness, simplicity, administration and efficient administration, the importance of transparent governance, and critically, the desire for this to be developed in collaboration, and for us to be really clear what this resource would be spent on and for. And all of those principles are really important, but balancing fair and simple, I know you'll agree, is quite a difficult balance to strike. And I'll come to that as we get into the details of our scheme. But before I get to the details, we were asked to provide clarity around what the purpose of an Edinburgh TVL would be. And for us, the purpose is very clear: to secure additional resources to invest sustainably in managing the success of tourism. This may be different in other local authorities. Clearly, what Highlands might want to do with a TVL, what Aberdeen might want to achieve with a TVL, and what Edinburgh might want to achieve with the TVL could be very different things. For us, we are really clear it's about securing additional resources to invest sustainably in tourism and to manage the success of tourism in the city. Beneath that, we're really clear that this is about securing Edinburgh's status as one of the world's greatest cities in terms of culture and heritage, which clearly impacts on our tourism, to secure future investment in culture, heritage, arts and sports, as we know tourism in the city is set to grow, to support the promotion of Edinburgh all year round and not just through the peak seasons, but critically also to recognise that support for tourism in the city is dependent also upon our residents and how they feel that tourism, the consequences of tourism, are being managed for them and for the visitor experience. And that balance between managing impact and investing sustainably is something that is at the forefront of the Council's mind. So when we come to what an Edinburgh scheme would look like, clearly the principles I discussed earlier have been at the forefront of our mind when we came forward with a proposal. Now, as Catch-22, we could have started this process with a straw man and consulted on it, but we informally engaged in order to get those principles and develop a proposal to consult on. And what those informal engagement told us was that fairness was really important to all the stakeholders, industry, residents, but also other parts of industry, so not just the accommodation providers, but our visitor attractions, our wider business stakeholders. In terms of the scheme, we heard really clearly that, to be fair, industry particular wanted to see all providers included, that it couldn't, one part of the market couldn't be disadvantaged or advantaged in the development of a scheme. We also heard that this applying across the whole system, the whole council boundary, was really important in order to ensure that it was simple to understand and simple to administer, and that applying it across the whole year rather than seasonally, again, was simpler to administer. In terms of the charge type, though, we haven't come down on whether, as a council, in the proposal, we haven't been specific about whether it should be a percentage or whether it should be a flat rate. And the reason we haven't done that is because informally what we heard from all of our stakeholders was very split. And so we wanted to reflect that in the questions that we were asking. A percentage might be more proportionate from impact and a fairer impact for your budget providers through to your luxury providers. But a flat rate undoubtedly is perhaps easier to implement and cleaner and simpler, but it might not be as fair. So we're asking also about, if you had a flat rate, how would you achieve fairness, and to what extent you'd provide exemptions to the scheme, to whom, at what points across the city, and how do you marry that with maintaining a simple, easy to run and clear to administer scheme. And that's the balance that we're trying to strike, and those are the questions that we're very transparently asking in the city. The other thing, obviously, that is of huge interest in this issue is how much it would raise and what would be done with the resources. The proposal we've got is for either £2 or 2%. Now, again, we are consulting on that, so we are really keen to hear from all our partners about where it is appropriate to pitch the TVL in Edinburgh. But what we heard in the run-up to the consultation was, if you are going to implement something of this scale with this change, make it worth it, make it an amount that you can invest and see impact from, but also be aware that we would be one of the first cities to do it in the UK, and think about how proportionate that amount is for industry. And so we've proposed £2 as 2% as we think balancing those interests and allowing us to implement the scheme proportionately and credibly within the city and without impacting in any way on demand and supply within the market. So how much would it raise? For Edinburgh, our figures show, calculations show that £2 to 2% would raise between 11 and 13 million. Now, clearly, that is a significant amount year on year. And also, if you were to use it to leverage other resources, it could have an even greater impact. Examples, and these are not in any order of preference, and they are not describing what Edinburgh would do, but examples of how other cities have spent resources raised by TVL to the side, including marketing, but also importantly, waste, refuse collection, street cleaning, community safety, public transport support. Those infrastructure and support mechanisms that a council provides that allow our tourism to succeed. So, Edinburgh Council has been clear so far that we do not see TVL as being a mechanism for resourcing our statutory duties. the expectation is there that Scottish Government, through a local government settlement, resource local government to meet its statutory obligations. And that's why the focus for Edinburgh is on additional, and it is on additional spend to sustainably invest in our tourist economy. The consultation asks specifically what would this look like. But interestingly, some of what we've had back is if you're going to have impact with this resource, spreading it across a large number of projects equitably and fairly might not be the best way to utilise the resource. And it may be that targeting it on one or two large programmes of activity would have greater impact and be more meaningful for the industry and for our city and economy. These are things we are testing in the consultation. But you can see the list that we've made available. I should really keep moving my notes. So the other two issues that have been big issues that keep coming from every stakeholder that we hold around governance and accountability and around administration. Both of these are very reasonable concerns to have. I think around governance and accountability, while clearly any scheme we have would need to be operated by a council and subject to our normal financial controls and governance, there are ways in which we could provide assurances that around governance and accountability that more obviously and directly involve our stakeholders as advisory groups that hold us to account in a very public way. Now, we're consulting on how we can best achieve this, and I think the principle is accepted by the council. It's just about how that would work in practice. But administration is a joint concern. Nobody in the council, this includes the council, industry and council, are jointly concerned that this is simple to run, it's cheap to run, it's administratively easy. That as an overriding principle obviously impacts upon the choices you make in the details of a scheme. I think the good thing, as I said, is that we are not the first people in Europe to implement a TVL if we get the power to do so. So we would be looking at best practice across Europe in this space. The big hoteliers that operate in our city apply TVLs in other cities in Europe. They have systems that we can learn from, and they have mechanisms both in terms of registration, collection, and compliance that we can learn from. The other thing to say is that Airbnb also as an online operating system has been really clear with us that this could be done very easily from their perspective, that they have the package to turn on, if you like, in terms of Edinburgh. And I suppose we would be working with those partners to make sure that what we come up with is practical, is industry-led and industry-informed, that the mechanisms work for industry, who would have the responsibility to collect, and that also we use this as an opportunity to explore what we could do digitally to make this an easy system to run, a modern system to run, and one fit for purpose into the future. So for me, clearly our commitment around this is to make sure it's simple and easy to operate, and our commitment is that we will work with industry to ensure that that happens, and we will learn from industry in how it can best be implemented. So, how could this be taken forward? Now, Edinburgh City Council's preference is for primary legislation, and COSLA have also been clear in this space as well, that what we are asking for is a high-level power to apply a TVL. Now, we're asking for this in general terms and at that principled level because all of us recognise that what Edinburgh might want to do with it would be very different to other parts of the country. Also, the power to do it is not the duty to do it. And so the decision as to whether it would be economically appropriate in a particular council needs to be made in that locality by that council. And so we would be looking for a permissive power that allows for those decisions to be made locally. There are opportunities, the local governance bill being one, where the Scottish Government could take this forward if they so desire. But also, other parties who supported it have been clear that there are other mechanisms, such as private members' bills, for taking it forward in primary legislation. So this is our preference. It's how we'd like to see it happen. But that decision needs to be taken in the first instance by the Scottish Government. What the Scottish Government could also do is amend legislation to enable this, and by that the Local Government Act. And as I've said, repealing section 22, which places a limit on local authorities to raise money by a levy or levy other council levies and rates. Now, amending legislation is always a blunter tool, and so for us, I think the debate and the time to work through a piece of primary legislation would be much wiser, but it's balancing speed and ease against the timescales of primary legislation. If that doesn't happen, there are other ways in which this could be taken forward. Some would argue we could do this voluntarily at the moment by negotiating with our industry partners. And technically, that is true. However, in the engagement we've had with industry, that fairness and the point that any TVL would need to apply to the whole industry is a really important one, and it's very difficult to achieve through voluntary negotiations. If you were to have a voluntary negotiation in a local authority, you would need to ensure that it was legally binding and contractually tight so that you could secure the income that was coming from tourist levy. That in itself presents problems in negotiating and agreeing, and in terms of timescales, probably looking at a much longer lead-in time to deliver. We've also been asked why we wouldn't move forward with the business improvement district model of raising income through a tourist tax through the business improvement district. And I suppose for us, there are a number of reasons why. If you're looking at resources and impact, it wouldn't raise as much as a TVL. If you're looking at practicality and flexibility, bid resources need to be spent in a particular way, in a particular geography, and that doesn't match what we would want to achieve with the TVL scheme. And it also doesn't provide security of income in the same way as having the power to levy a tax would. And that means that you're limited in how much you could utilise that money for impact. So if, as a city, our partners said to us, for example, actually this capital project would really benefit the city, we could not, because of the insecurity of the income, utilise the TVL to deliver that project. And for all of those reasons, a bid is not appropriate or the best way forward in Edinburgh for delivering a tourist tax. In terms of the areas of complexity around the legal provisions and around the administration, compliance and enforcement of a TVL are clearly areas that Scottish Government would need to think about. For us, when we look at other schemes and how they've run, we know that the registration process is actually key to the compliance. It is also key in terms of who's liable, to understand that while this is a tax on tourists, the responsibilities to collect and pay would be placed on the accommodation providers. And so that balance of who is responsible and liable, and therefore if there were penalty charges, who would be responsible for paying them, rests in that space. what I would say is that while this is a power to raise a levy, there are other examples around licensing, workplace parking levy, other spaces where this has been done in a generic power that then is applied according to local circumstance that we can learn from as well. And it's not just European precedents that we would be looking to. And I think that through this process, if we achieved the support to implement a tourist levy in Edinburgh, this is the space where we would need to draw on those experiences and make sure that we had a mechanism to ensure that that it was difficult to avoid and that everybody was on an equal footing in terms of the legal parameters around the power. I've put this in simply to give you an example that we are considering and looking at. And this is important because, some of the concerns around this are around cost. And it's important to say that Lisbon have a twofold approach. They are looking at supporting industry to implement the tourist levy by allowing them to retain 1.5% of the levy collected to offset any costs, but they also have a mechanism in place for penalty charges should there be overdue payments or an absence of payment. Next steps for us are laid out in front of you, but basically we have a public consultation out at present. It closes on 10th of December. While it's targeted to Edinburgh businesses and Edinburgh industry and Edinburgh residents, we do have a mechanism for other surrounding local authorities, local businesses, local partners to be able to respond. And I would encourage as many people who have a view on this to do so. Clearly, there's also a national consultation which will be ongoing. And my understanding is that would happen within the timescale also of the spending review negotiations that are happening.
To make a quick start on our next session, something a wee bit different from what we heard the other two speakers speaking on earlier. A great pleasure of mine to introduce Sandra MacDonald, ex-PG, to speak here this morning. My colleague Neil and I were at a dinner last night, Scottish Care dinner, and Alan Blair, who used to be the Chief Advisor on Social Work to the Scottish Government, was speaking at a very personal level about the transition that he had to make from being a social worker and a professional to someone who had to be a son securing residential care accommodation for his mother who had succumbed to Alzheimer's, and just the difference it makes when you're engaging with professionals who are dedicated to excellence and who have teams around them who are dedicated to excellence, who make those choices easier and make that transition easier. And myself and my siblings went through a similar process just about 2 years ago when my father succumbed also to Alzheimer's, and going through that process of being a lawyer who's suddenly a daughter, who's having to think about becoming a guardian, and on one hand thinking that should be easy for me because I'm surrounded by all this expertise and Brodies who should help me do it, but finding the practicalities of being a guardian and all that involved in terms of the form filling, the paperwork and just the emotion that goes into that, but finding that, as it was then under Sandra's watch, the team at the OPG being very supportive, being very good at correcting my arithmetical errors without upbraiding me for it, and making that process, which is very complex in many ways, so much easier to do because of the support and assistance that they gave us as people rather than professionals. As I said, that was under Sandra's watch. I think that she has developed a team there who are committed to excellence, now continuing under the present OPG. So on a very personal level, I'm delighted that Sandra is here to talk about what's happening with adults' incapacity and hopefully how the legislation around that and the approaches can be made more proportionate and perhaps a little more easy to engage with.
Mm-hmm. Thank you very much for the invite to talk today. I'm going to focus on the Adults with Incapacity Act reforms, and I appreciate that some of you might be thinking, well, that doesn't going to be involving me because professionally I'm not in that field. I'm doing something completely different, so I'll just switch off for the next 3/4 of an hour. But as Jackie's highlighted, actually it could impact on any of us because we've all got older parents or siblings that might be of a similar age to us and might need some support in the years to come. And increasingly I look at myself and think, do you know what? That's going to involve me potentially because the current Incapacity Act is a 2000 Act, so it's been around the best part of 20 years now. So I think the reform that we're putting in now, if that's going to be around the next 20 years, there's an incumbence on me to make sure I get it right for me. So this is what I'm going to talk to you about today. And obviously, any of the fields that you're involved in, you might also come across an adult or a carer of an adult with incapacity. So hopefully it's relevant to you, even if it's not your direct work. So I'm going to talk about all of these things, and I've got about half an hour, so you might think, oh my goodness, how's she going to achieve that? But it is literally a whistle-stop tour, headline of each of them. And I'm currently working with the Scottish Government on the Adults with Incapacity Act reform, and so I can give you the updated position as of 2 days ago. I'm doing 2 days a week, Tuesday, Wednesday, so I can give you up to Wednesday's news on this. Not that it changes that rapidly, I have to say. That makes it sound good, doesn't it? So just quickly, though, first thing I wanted to talk to you about the Office of the Public Guardian personnel changes, as Jackie's alluded to. So I was the Public Guardian for Scotland for 14 years, up until about 2 months ago, but needed more personal flexibility of time and needed to just reduce my hours to maybe those 2 or 3 days a week as opposed to full-time. So I chose to leave. Fiona Brown, who was my deputy, has been appointed now as the Public Guardian, and Carrie, who's there, is the Interim Deputy Public Guardian. Both Fiona and Carrie are Scottish Court Service personnel. So Fiona's a permanent appointment and Carrie's interim, and that post will be advertised in maybe, I think Carrie's in till March, so sometime after that. So if you do have direct contact with the office, I know some of you do, those are the names of the new post holders. So to move on to what I had as my first little bracket there at the top, I was going to talk about the AWI, Adults with Incapacity Act principles. So there's some principles underpin the Adults with Incapacity Act, which are these. I'm not going to go through them all because those of you who are involved know them, and those that aren't don't need to know them in that level of detail. I think the thing to point out is they aren't in any priority order. So a lot of people who are using them, they say, oh, right, so such and such we're going to do. I can show clearly the benefit to the incapable person, so I've ticked the boxes. But actually, you've got to go through them all. So for now, they're in no priority order. However, in comes respect for the rights, will and preferences of the adult. So there's going to be a change to the principles to include this one. And most probably, it's going to get a priority order. So from having no priority, this respect for rights, will and preference is going to be the priority. That doesn't mean to say that if you can show that you've respected the right and the will and preference of the individual, you don't need to meet any of the others after that. They are all still involved, but you absolutely would have to ensure that you met the first one before you could move any further. Just to give you a bit of background where it comes from Article 12.4 of the United Nations Convention on the Rights of Persons with Disability, abbreviated to UNCRPD, or sometimes you'll just hear it CRPD. And this is what the CRPD says, just so as to try not to send you completely to sleep just before your lunch, that state parties shall ensure that all measures that relate to the exercise of legal capacity shall provide for appropriate and effective safeguards. Such safeguards, and the safeguards that are under the Adults with Incapacity Act, safeguards shall ensure that measures relating to the exercise of legal capacity respect the rights, will and preferences of the person. So that's where that comes from. It goes on to say, are free of conflict and undue influence, and are proportional and tailored to the person's circumstances. So save those latter two, because I'm going to come back to them, because for now we're on what rights, will and preferences. So, respecting the rights, will and preference, there's three things in there. They do have the potential to be in conflict with each other. So somebody might be absolutely terrified of needles, let's say. So their will might be to withdraw from having any treatment that involves having needles. But their preference would be to have the treatment and to be out of the pain or whatever it is that they're going to need the needle for. And their right is obviously to have good, appropriate healthcare for whatever the condition is. So the rights, will and preference can be in conflict with each other. And so for the lawyers in the room, it will be a case of, well, what will happen when the rights, will and preferences are now in conflict with each other in a significant way, and we can't find a way of reconciling. So I'm sure there will be in due course some case law which will look at, is there a pecking order within rights, will and preference, because that's the order they're stated, and so are the rights more important than the will or the preference? And how would you decide that if particularly the will and preference are in conflict? So watch this space on the case law on this one. Another one that's going to come in is encouraging the support for decision making. So you'll recall the slide that I just had on before with the UNCRPD. It talked about support to make a decision in the exercise of their legal capacity. So there's going to be something, again, and I've put it at the top of the list because it's likely that it will be given a prioritised ranking along with, equal to, the rights, will and preference. But above the current priorities. And so how would we ensure that we encourage participation? It's sort of a little bit aligned to some things that are in there already. Account of past and present wishes is in there already, so that's sort of like rights, will and preference. And maximising the person's abilities is in there already, which is sort of like encouraging participation. So it's not a million miles from where we are, it's just the force or impact or prioritisation and the focus that's going to be on them. And certainly if you were bringing a case to court, you might have to talk about how you've encouraged the support for the decision making, or how you've respected the rights, will and preference. If any of you bring in cases to court, certainly in Edinburgh at the minute, or in Tayside, Central and Fife, the practice notes of the Sheriff Principles there demand some commentary already before the law has even changed on how you've met these criteria. So a little bit more about the support. So it talks about support that they may require in the exercise of their legal capacity. Just mentioned that, you saw it on the first slide, but you see it on this slide too. So is there a difference? Because supported decision making is the phraseology that's getting bandied about, and other countries are doing supported decision making. Scottish Government have had Jan Colleen, for those of you who know Jan, very heavily involved in this field for many years, do a report on supported decision making and what our gaps are. And so the process has been on, the focus has been on supported decision making, but actually the fine detail and the lawyers that have the academic brain will say, but it's not supported decision making, is it actually? It's support for decision making in the exercise of legal capacity. So what's the difference between supported decision making and exercise of legal capacity? And I think for me, the supported decision making takes you only so far. And for those of you who know the Adults with Impact just now, if you remind yourselves, let me just know, it's not the next slide. If you remind yourselves of the capacity assessing, and it talks about of acting and understanding decisions and making decisions. So a lot of the current definition is around decisions. So that's where the supported decision making comes in. But the word acting is there at the top of the list, doesn't have anything after it. So acting is very broad, and I think that's where exercise of legal capacity comes in. So it's all well and good if I'm a person with impaired or incapacity, and I decide that I would like to sell my house. And it's a decision that I'm quite clear I've made, and I've understood that decision, and I know that it means I no longer have a home and I'm going to have to live in a care home or whatever it is. But I've been supported to make that decision, and I'm happy it's a decision I've made. That's only one part of it. Because in order to exercise my legal capacity, I've got to go through a whole process to formally sell a house. And a legal process, and I might not be capable of exercising that level of legal capacity because it's a big exercise. So I might need somebody to do that on my behalf, even though I've been supported to make the right decision. So there is a difference, and the legal academics who pull us, officials, if you like, on the difference are correct to do so. So I would say to you, if you're in a field and you're hearing supported decision making, and you think, oh, I've got to make sure I support decision making, yes, that's great, but that is only a portion of the picture. Really, the picture is on exercise of legal capacity after that. So make sure you're offering the support to the person to make the decision, and then you can support them. You've got the mechanisms in place to support them to then exercise that legal capacity. So you've got a twofold thing under that heading. So I'm mentioning capacity quite a bit there. So thinking about some changes to legal capacity assessing that are going to be on the cards. So currently, I've just sort of run through it. Currently, the person must be, the person is incapable if they're not capable of acting or of making decisions, communicating, retaining the memory, understanding the decision. And those are all predicated on by reason of mental disorder or inability to communicate. So the United Nations have an issue with this because this is divisive or inequitable, because it means that some people are going to be incapable and others are not because they haven't got a mental disorder or inability to communicate. There's also a massive big debate going on about dementia. So because dementia is a neurological disorder, not a mental disorder. So actually, or anybody with dementia arguably doesn't meet the criteria for the Adults with Incapacity Act because they haven't got a mental disorder, technically speaking. And the definition for mental disorder in the Adults with Incapacity Act is found in the Mental Health Act. And so, so again, it definitely restricts or excludes people with dementia, for instance, because they haven't got a mental health issue. They've got a neurological issue. So arguably, the Mental Health Act for people with dementia, the Adults with Incapacity Act for people with dementia was flawed from the word go. So, but nobody's ever challenged that point, but it does come up at the minute. So, hey, guess what's going to change? The definition is going to go. So there will be no gateway entry test. So anybody who, on a functional level, meets this criteria would be classed as incapable. The problem for me, I think, and maybe for some of you, is that that opens this potential up to people that were maybe never intended to be in there. So the one I think of typically is maybe domestic abuse. And so I'll say a woman because primarily it tends to be women. So a female who's in an abusive relationship cannot leave that relationship, though, because of family commitment or the children or the cost or maybe her own psychology. She needs the gentleman that she's with. Oh, gentleman, that's a bad word, isn't it? She needs the person that she's with because of her own psychological makeup, and cannot extricate herself from that abusive relationship. She would now arguably meet the criteria, because these are not and, these are or. So if she's incapable of acting to safeguard herself for whatever reason, she would now meet the Adults with Incapacity Act. And I don't think that was ever its intention. So it's a difficult one. What's going to go in, the definition, the gateway entry on diagnosis has come out. What's going to go in is not acting under undue pressure. And that's sort of in at the minute. It's a bit implicit. It's in the certificate. For those of you who are familiar with the capacity certificate that you have to complete, it says it in there when you're declaring that the person is capable because they're not acting under any undue pressure or other vitiating factor. But it's not actually on the primary legislation, which I think is an omission. It's not included in that legislation, so it will be in future. So you'd have to satisfy yourself that they're definitely not acting under any undue influence or pressure to agree to, say, the power of attorney or guardianship. There's also going to be an increased focus on consent, because there's a view at the minute that too many people assent to something rather than consent to something. And so along with ensuring that we've supported their decision to exercise their legal capacity, that they meet all that capacity criteria, etc., that also they are consenting to whatever it is and not just assenting to it. And the consent stuff is being picked up very much topically from the sort of Me Too type campaigns and the consent to sexual relation campaigns that are going on. So consent, we would have to be able to demonstrate that the person has been active in their consent. Just because they didn't say no doesn't mean they haven't, that they sort of haven't, they've given consent. So the typical one that comes up there is a person who is maybe in a care home and needs to be moved, or in a hospital and needs to be moved to other accommodation, or is at home and needs to be moved into a care home. And they seem to be compliant, but maybe they're compliant because of the nature of their illness. Doesn't mean to say they're consenting to something just because they haven't objected. There has to be based on equal power, and I suppose this comes back to the undue pressures. If someone feels under pressure to say yes, then this isn't consent. So the lawyers who do this area of work, particularly, they're asked to make sure when they're interviewing the adult that the adult is on their own usually, and particularly the person who's going to be guardian or power of attorney is not in the room at the same time. So that you can be more satisfied that the person is not feeling pressured to say yes. Absence of the person that may be the person that's giving them pressure doesn't necessarily satisfy that entirely, though, if you think about the domestic abuse type setup. Choice, the person must have an option to say no, and that consent is a process. It requires ongoing conversations. Just because someone said yes once doesn't mean to say that it's always a yes. You can see it in the sexual relations type of setup, but it's going to be picked up and placed into an adults with incapacity framework as well. So some of the practitioners in this area are sort of, how are we ever going to do this? But actually you say, but it's what you do now, really. It's just codifying it, because you're always having a conversation with somebody and checking where they're at, and whether they want a bath that morning or whatever it is. It's just an iterative process you go through with your client. So don't be scared by this. This just sounds like big lawyerish stuff when actually it's what you do day to day anyway. So, moving on, some potential changes to the way the power of attorney operates. Many of you, even if you don't work directly in this field, will have seen a power of attorney, or will have clients come to you that say, I am the attorney for. So these are the changes that can be expected here. Firstly, that the capacity decision will be spelled out. Hooray! For those of you who know about this, this capacity decision, at the minute, all it says in the power of attorney is, I confirm I have considered how my incapacity will be determined. And that's it. And it doesn't mean a thing, because what was the outcome of your decision? Do you want to, when my attorney reasonably believes that to be the case, or when a doctor assesses that to be the case? And so the amount of complaints or arguments that would arise when I was in the OPG with people who were saying, you know, my relative wasn't, you know, this power of attorney has been operated and it's not being operated. And I think if they'd only just said at that point, so if you've considered how your incapacity is going to be determined, then there's an answer that can go in there. And so now the capacity decision is to be spelled out. So good. Clear powers and authorisations. I think the some of the powers are a little bit woolly, and particularly this one's going to focus on what should be said for deprivation of liberty type issues. If somebody is being maintained, has to be maintained in a care home, for instance, beyond against their will, rights, will and preferences again, what clear power and authorisation is there going to be, and how is that going to be spelled out? I think it's highly likely that the samples will return for those of you who, well, Brodie's particularly represented the Office of the Public Guardian, and Neil somewhere is, he's gone, but Neil was very involved in that, Neil McLean. So there was a whole issue with the way the samples were available on the Public Guardian's website, and so they got taken down as a result of that case. There's been a lot of furore over it, so they're likely to be going back. This will be because of Scottish Government approval now, rather than the Office of the Public Guardian simply putting them back. Public Guardian may be able to defer registration. At the minute, the Public Guardian has to register something, even if there's an issue over it, or if not, go to court. And so this is quite a heavy-handed process involved at the minute. So I think the suggestion is that the Public Guardian should be able to defer registration on cause shown, subject to getting further reports, and then make a decision: can I register or can I not, with an appeal to the Sheriff Court if required. The Public Guardian would be able to supervise power of attorney. At the minute, the Public Guardian does not supervise powers of attorney, largely because it's a private mandate, if you would think of it like that, between yourself and the person you're appointing as your attorney. So why should some state body then supervise it, suggesting you're not making a right decision? There is an investigation service if somebody wanted to refer it at a later stage because they think the attorney's not doing it properly. But if the Public Guardian then finds an attorney not doing it properly, again, it's a court process to have to supervise the attorney. You can't just step in and supervise. So there's a suggestion that the Public Guardian will be able to supervise the attorney on cause shown, again, that these are the reasons why now I think you need to be supervised, with an appeal mechanism to the Sheriff to say, I don't think it's right that I should be supervised. And then final point on that is whether there's going to be cation. Cation is an insurance policy, and it's available in guardianships now. Most guardianships are required to have this insurance bond in case the guardian either negligently or deliberately maladministers the estate, abuses the estate financially. So there's a debate about whether there should be a small bond on powers of attorney as a mandatory matter in case they do likewise, and they do so more often. So that's the point we're at. We're making good progress. Moving on to guardianship. There's going to be some form of grading of guardianship. You will recall in the consultation that was out earlier this year, there was 3 grades suggested. It's now down to 2 grades. And with both of them going to the Sheriff Court, one of them, grade 1, being a very much abridged application, maybe with a social work report and a GP or registered medical practitioner report, and then level 2, much in the way we've described now, with a section 22 psychiatry report and a mental health officer report. And the division will be determined in legislation, so you would know whether you were a grade 1 or whether you were a grade 2 on applying. But the Sheriff, if you applied at grade 1 and the Sheriff genuinely thought there was a reason to put it to 2, would be able to remit it to 2, so you wouldn't go back and have to start all again. The detail is still very much under debate, so I can't really give you much more than that. The stakeholder groups really fleshing out this detail at the minute. But those are the two grades that are being looked at and how we would define those in law. And you'll recall there was a debate about sheriff court or tribunal with the conversation. I think it's fair to say that tribunal won out, big style, but the government for now have decided to stay with the sheriff court. Reason being is because there's longer term a look at whether the Mental Health Act and Adults with Incapacity Act and Adult Support and Protection Act, which are the three sort of triumvirate of acts around this area, should actually be fused in some way and should become a unified legislation. And in which case they feel a tribunal would be a better place for those three. Not necessarily the current mental health tribunal if it was fused, but a maybe a vulnerable persons tribunal or whatever it would get called. So what they don't want to do is move it to a tribunal now, which would be the mental health tribunal, only to have to move it again to some other tribunal in a matter of 5-10 years' time. And particularly they can't move it to the mental health tribunal now because that would be putting the label back on it again, which I've just said was going to be removed. So they haven't got a tribunal to put it to at the minute if it isn't the mental health tribunal. So it's staying with the sheriff court just now, but longer term there may well be a move for a tribunal. Intervention orders, debates actively ongoing at the minute about should they remain or should they be subsumed within guardianship. In all honesty, I think they'll remain in some form for some things, but probably not quite in the way we see them now. So watch this space on intervention orders. It's possible that the name might change. I think the word intervention is quite confusing because you've got interventions, the word intervention appears all over the show. So they might get changed to a sort of specific issue order or some title like that where you define it for something, which is intervention by another name but maybe less confusing. Deprivation of liberty, the big one that everybody wants some information on. Sorry, I don't come with this magic wand today. There will be some direction on deprivation of liberty. There has to be. Whether an attorney will be able to deprive someone of their liberty, technically speaking, will need to be agreed as well. There's a debate about that, or whether it has to be guardianship, a guardian that can do it. And what is deprivation of liberty? Because the Scottish Law Commission reported on what their view was and it bombed at consultation. So there's still no real consensus on what is a deprivation of liberty. So this is a biggie that's all being worked through at the minute. So there's no definitives on this that I can give you today, except to say that there will be direction on it. There will be determination on what is a deprivation of liberty or what is not, and whether attorneys or guardian attorneys particularly, whether they can authorise it. And there'll need to be prescribed wording over it, because unless you put a prescribed wording in, some care homes or users will, agencies that are seeking to rely on the power of attorney will say, but I'm not sure whether that's sufficient or not, and still want the person to go to court for a guardianship order. And so I think we would have to see, as a minimum, this form of words is okay. And any more that the client wants to put in after that, that's entirely up to them. A short-term placement order was very much asked for to allow for a quick move between, usually from hospital to care home, stop the delayed discharge that is going on, particularly in some hospitals. So on that one, a new order is likely. There's a debate about how necessary it is or whether there's sufficient powers. So again, the stakeholder work still very much ongoing, but at the minute it's in favour of a short-term placement order coming out. How much it would be used, that's the debate about how necessary it is. But I think it'll go into the revised legislation, even if it's not used very frequently. Support and supervision will change. So guardianship support, you remember way back at the start I told you about Article 12.4, tailored and proportionate, told you to remember those words. Well, the public guardian is looking at how they tailor and make more proportionate their supervision, and the local authorities have been asked to do likewise. So even next week I've got a meeting with them about how we make more tailored and proportionate supervision. So you'll see changes in the way guardians are supervised. We've talked a little bit about the supervision for powers of attorney, and we've already talked about potential vacation for powers of attorney. So that's all under changes to the support and supervision. And cross-border, for those of you who this is a bit of a nightmare at the minute, under the Hague Convention for the international protection of adults, what can you do in one country compared to what can you do in another country if they move from Scotland to even England, or if they move from England to Scotland or another country to Scotland, what can we do? What authorities do we have? What authorisations do we need? Do we need to take it to court? Do we not? Can we operate on that foreign order, or do we need to have a Scottish order, and vice versa? So all that is going to be clarified. So that's good. And finally, the wish list. You can't really see that picture very well, but that picture was from a film, and I just decided to put that in because I was going to put a test to you, but it's actually got quite late on, so I'll not bother. But it's from Field of Dreams. So I thought I quite like this Field of Dreams because it's a bit of a wish list here. And of course, the phrase from Field of Dreams with "if you build it, they will come." So this was, if we give the wish list, then maybe these, you know, it gives an AWI that's going to be more workable for these aged generation that are coming along. So the wish list, those of you who are involved in this field, you will know that as the public guardian, I was keeping this so-called wish list for years now of changes that would help, clarifications or minor amendments that had come about as part of the cases that we were working with, that you would then say, do you know what, if that was just tweaked a bit, or that's a bit confusing still. So the wish list still exists. It's got about 100 items on it. A few more than that, I think. It's got about 100 items on it, and the government have said they will action all the items that are on the wish list. So thank you to everybody who's been keeping that wish list. If you build it, they will come. So I think that's probably it. Anything else we have time for? So we've got about 10 minutes left for questions. So this is me now acting independently as opposed to as the public guardian, and these are my contact details if anybody needs it. So I have 10 minutes for questions, I think, if anybody has any questions.
Does anyone have any questions for Sandra? I think it's a really good opportunity to have someone who has got the insight into why the changes are necessary and how they might develop. So if you do have questions, this is a good opportunity to put something in front of it. I have one, but doesn't.
I got away lightly compared to the.
I have one, but it doesn't really relate to anything
Tourist levy
thus far, and it's really in relation to guardianship in a situation where it's quite clear that a local authority may be appointed as a welfare guardian, but you do have a situation where no one is willing to come along and take up the role of financial guardian.
Yep.
And almost as a guardian of last resort,
yes.
if you like, the local authority may step into that arena.
Yeah.
And I think the Act is at best ambiguous on that.
Yeah.
And it has been suggested that a local authority acting in a role as a financial guardian has potential to give rise to conflict of interest.
Yes.
Where that local authority is providing services directly to an adult with incapacity.
Yes.
So, for example, residential care.
Yeah, yeah.
And I know that some local authorities will very much pull back from that, but in some areas, perhaps more remote areas, it's much more difficult to pull back, and ultimately they will step into that arena. But it doesn't seem to me that the legislation as currently framed provides for adequate safeguards where local authorities have to take up that mantle, which I think is perhaps unfair not just on the adult who has the incapacity, but also on the local authority as to the parameters within which it should operate. Is that something that has been considered?
It has. Currently, what most local authorities do to try and prevent that conflict of interest is ask a local solicitor to be the financial guardian. So they'll do the application, but they'll nominate Mr. such a body from such a firm, local solicitor. But it would, it would be more helpful, I think, if they could be the guardian themselves, financial guardian themselves, if they wanted to be. And the discussion has gone around a bit like the access to funds. I don't know how familiar you would be with the access to funds, but the access to funds scheme, which is operated by the public guardian, will go. I didn't put all of the detail on of everything because it would have taken me all day. So the access to funds scheme will go because it's a scheme that is really unnecessary in the sense, if guardianship, the low-level guardianship would be better, the level 1 guardianship that I talked about will subsume the access to funds. But access to funds has got a lot of merit for what you're just talking about, because the way in which a local authority can register to be the withdrawer for access to funds, and the registration process which the Public Guardian's Office goes through is almost a safeguard in itself, because they have to report how they manage funds, how they hold funds, who's the post holder that does this, that and the other. So I think there's probably, the suggestion is that will be a lift of the access to funds type framework that under the low-level guardianship, once a local authority has passed the test, if you like, as a suitable guardian, which they all will, frankly, then your option will be, well, you can then manage it yourselves as a local authority or continue to give it to a solicitor. It's entirely up to you. Managing it yourselves would, because the supervision has got to be tailored and proportionate, and you're a local authority, you're already good guys, so you'd get low-level supervision on those sort of cases. So it would open another option for you. The key thing would be that the person who was, a bit like the Chief Social Work Officer and day-to-day social worker, are quite different. So the Chief Social Work Officer is the welfare guardian. That may be delegated to the day-to-day social worker in reality, but the post holder has a distinct responsibility. And in that way, so the Director of Finance might be the financial guardian, and the responsibilities may be delegated to the day-to-day officer, but those two would have to be a distinct separation, so that the financial guardian was not the person doing all the day-to-day stuff, because that would be potential for abuse there and nobody knowing it. So again, it's a bit devil in the detail, but yes is the short answer to your question. It has been thought about how local authorities may be better placed to be financial guardians.
Just one further thing, just indulge me. On this new test that's like to come in and be prioritised, I mean, one thing that occurs to me is, being someone who's been through this with a parent, is that it's quite easy, I think, to define what someone's will and what their preferences or their consent might be at the outset.
Yes.
So a parent, in my case, may have a very strong desire to remain within their own home.
Yes.
But that can change as they find that access to the outside world is curtailed.
Yeah.
And over a period of time, they may come to realise that it's in their interest. They may thrive more in a residential care setting where they're able to socialise much more readily. But it's that notion of keeping that change of preference, if you like, change of will under review, it seems to me will have become more emphasised under the changes that are coming in the legislation.
I think so. And one of the things we'd have to work with attorneys or guardians is note keeping, because they don't keep notes at the minute. So if you've decided on a change of pattern for whatever reason, then just a quick note of record of why you've changed it. Most likely it'll change the other way around to what you're talking about, is that the person may have understood whilst they're capable that they might need care home, or they might have understood that they want this person to be their attorney, and then their condition changes, and particularly in early dementias where they get a paranoia about things, they might decide they don't want this person now because this person's going to potentially abuse their affairs, and they don't want anybody, they'll just do it themselves. And so their preference when they were capable was to nominate their daughter, but their preference now they're beginning to incapable is to remove their daughter. So do we just remove their daughter because we've got to respect their preferences? But they've also got the potential conflict then with past and present wishes, because that's also in there. So their past wish was to nominate their daughter, and this is how the conflicts are going to come about. So I definitely can foresee some potential, not cases that go to High Court type level, but definitely some sort of Sheriff Court referrals to say, what am I going to do here? Because remember the Section 3, which is a Sheriff Court referral for a direction on how I might fulfil my responsibility, is not, it will still be there. So it'll be advocated to say, go and ask the Sheriff what you do, because there's potential, especially if it's around care homes and whether they move or not, potential deprivations of liberty going on if they then were saying, I was okay with it when I was capable, but now I really don't want it, and you're going to take them away out of their home. So this is an area of law that will develop cases on that people like yourselves are going to have to follow.
Well, Sandra, thank you very much
Thank
for
you.
coming along.
Thanks very much.
Very informative. Thank you. So we're on the home straight. Our next and final speaker is Alan Nichols, who is a partner in Brodie's personal and family team and who has considerable experience in the field of charity law and in advising on ALEOs. You might wonder why someone in a personal and family team is involved in ALEOs. It's perhaps not that odd, because when I think about it, he has been there when they have been born, when local authorities and other organisations have given birth to them. He's been there when they've needed a bit of looking after. He's been there when they've needed a bit of corrective treatment, when perhaps they've gone off the rails a little, and more recently he's been there when they have been dispatched. So I think he's very well equipped to speak on that very broad subject of ALEOs in 2018.
Thanks, Jackie. Let's see if I can make things work. Yes, I can. And actually, it's as if these things are planned, because I was going to start by noting that this morning somebody messaged me on LinkedIn, having read one of my incessant posts on there about governance and stuff, and they said that I had a passion for governance. So I immediately was on to the monumental mason saying, November 1980, Alan Nichols, just date left at the other side, and then just a passion for governance is what I will have on it there. Governance and accountability will be a couple of things that I will mention as we go through today. And ALEOs, a journey. ALEOs have very much been on a journey from when they sort of arrived on the scene, and individual ALEOs will have been through a journey. I also think it's the right time of year for a journey, because it's X Factor and Strictly time where everyone goes on a journey. So I thought that felt right. And ALEOs have been through a journey of how they've been used and how they were born. Oscar getting interested in them. Audit Scotland Accounts Commission looking at them. We've had the Barclays review, very much looking at some of the benefits and perceived reasons for ALEOs there. We then move on from actually how is Barclays or parts of Barclays going to be implemented, and what are the impact for existing and new ALEOs there, which will take us into potential legislation, and actually just generally what might the future hold here. One thing I think is very important to think about with ALEOs, particularly looking at the future and now, is what on earth is an ALEO? Now, that is not a great starting point for someone who has doing a talk on ALEOs to go, what on earth is an ALEO? But I think that's quite an important thing, is that there has been a dangerous mythology attached to a tag, and it's trying to capture all sorts of things. Let's create an ALEO, let's have an ALEO, that's an ALEO, when all of these things could be hugely different, both in terms of what they're trying to do, how they're set up, etc. So I think certainly for the future is actually trying to resist attaching ourselves to a tag like an ALEO or whatever tag comes along, and then to really try and look at what the characteristics, features and benefits we're trying to get out of any structure that we are creating. And I think that avoiding the tag what kind of thing, they do services, they do big regeneration projects, they work with the community. Sometimes they're very commercial animals. Sometimes they're holding property or managing property. Sometimes that's in the ALEO itself. Sometimes it's in trading subsidiaries. So there could be a whole range of vehicles used to hold and look after particular assets. Sometimes they're delivering important services such as social care. So there's this huge breadth to this segment of the legal world, sometimes of the charities world, and we have to recognise that because of that breadth, then the idea of there is just something called an ALEO just isn't true, and I think that's going to be particularly important in the future. A lot of them are charities. I tend to get involved in ones that are charities because I know something of charities. I know nothing of anything else, so I focus on the ones that I have some kind of clue about. But they have been very much the focal point too. They're not all charities, and that again is another aspect of there's no such thing as an ALEO. Some are LLPs, some are companies, some happen to have a charitable status, some do not, but many of them have been charities and they have been a bit of a focal point generally. If you have existing ALEOs that are charities, one of the things that can be very important, particularly around ones that could be coming to an end or moving into a new phase and people want to start moving assets around, is that when you put assets into a charity, it is a bit of a one-way street because charities have an asset lock. You can't just get those assets back. If the member, often the local authority, it can't just get those assets back because they're in a charity. And if you want them back, you have to buy them back. And you have to do that at market value. So that asset lock is a very important thing for people to remember. Ideally remembering before the assets are put into the charity, because then they're gone, and you can't just get them back at a whim. But certainly remembering at other key moments that these assets are in the charity. They are out with the direct control of the local authority, and that is very important. And it just says a lot about me. There's a BBC trailer for drama generally at the moment, and it's got a bit from The Bodyguard where David Budd is saying to some bad person, that they cannot move an inch or something like that. And that is what the asset lock is like. Once those assets are in there, David Budd, Bodyguard, is telling you that is it. They must stay there. They cannot move. And that's a very important thing for people to remember. It can avoid disappointment at a moment where you say, we'd like to move these around, and that becomes a bit more difficult to do. And sometimes they're in trading subsidiaries, and that also can create issues if you're trying to rationalise property portfolios. And we have to remember, if they are within this charity structure, then there are things that people really have to think about before they can actually be moved around. And of course, it just brings us on to why do any of these exist? Often it was to do with certain tax efficiencies and creating a level playing field. We will come back to the phrase level playing field because it can be used all sorts of ways. But at the very outset of people thinking about ALEOs and more recent ones, people are thinking, we want to be able to put certain services, certain properties on a level playing field with other entities out there. They are currently within local authority. If we were doing this a different way through a charity, the level playing field would mean that, for example, there would be charities rates relief. So there was a view that create a level playing field and a tax efficiency there. I'll come back to that phrase in a moment. Income diversification, are there other places people could attract funds into an ALEO because it's a charity or even another vehicle that either looks more charitable, more community focused, or looks more commercially focused, and therefore there was more flexibility to go out and work with others, get other contracts, do other services. And certainly for some that has been an opportunity that they have taken. For some, maybe not as much as people hoped or thought at the very outset, but certainly for some they have taken those opportunities. And sometimes maybe just a different focus can be attached to being an ALEO that is a charity or just a normal company. For example, you can have a different approach to things and deal with stakeholders and engage with other people in a different way. Oscar has been excited by ALEOs for a good while. They created guidance, case studies in their Who's in Charge guidance. This is very useful guidance. If there are any charities questions that come up, whether it's an ALEO or anything else, often this guidance will feature in giving advice or things that people should be looking at in terms of live case studies that had happened. This guidance was really Oscar setting out a stall that the trustees of a charity need to be in charge of that charity, to have an appropriate degree of independence of thought about how they run that organisation and make decisions, and that they shouldn't be unduly influenced or controlled by parties out with the trustee board. And a lot of it returns just to the fundamentals of putting the interests of a charity first. So that remains important guidance, but it was general guidance. It featured ALEOs, but it was general guidance. Oscar then, in 2015, took a more specific dive into the ALEO world, and they perhaps approached it with maybe a healthy scepticism. They were maybe bought into this idea there was some mythology around this mystical beast of an ALEO and what that could be. Oscar, perhaps because of the breadth of services and activities carried out by ALEOs, actually came out fairly positive in relation to ALEOs and said, yeah, on the whole, these seem to be good organisations with good governance. And Oscar was noting that, notwithstanding the fact that they may have a sole member who's a local authority, actually the governance and how it was operated in practice, and sometimes quite softly operated, worked very well. They seemed to be generally happy about how boards were composed, even though local authority councillors would be there. Oscar was saying that was an acceptable mix in most cases. They seemed to acknowledge that trustees were trained and that people recognised that they had to understand what it was to be a trustee of a charity. And a big bit, I think, of Oscar's analysis was recognising that all charities exist in a reality. They live in the real world where you kind of can't get it all your own way. If somebody is going to fund you, give you services to do, then you have to accept that there may be some degree of control attached to that, whoever you are dealing with, whether it is a local authority, a funder, even a member of the public who does a will and says, actually, this is how I want these funds, this legacy to be applied by that charity. That is an element of control as well. So I think there was a degree of recognising that there can be mechanisms for control and influence, but that is entirely appropriate if you are entering into various contractual and funding arrangements with somebody. The flip side because Oscar was looking at it from one angle, other people might be looking at it saying, well, influence and control is to one person maybe a downside, but on the other side, it is a way of achieving accountability and transparency. It wouldn't be right if an ALEO was just given lots of services, people, money, assets, and said, well, off you go. You're a charity, so we'll just let you go and do what you like. So there had to be some governance and accountability built in there, and it seems that Oscar accepted that was the case. They pulled out, they were interested in how the powers were used, particularly not actually using formal powers that the local authority as a sole member or one of a small group of members would have, and often using softer powers, memorandum of understanding, rather than actually using the powers that were in articles of association. Oscar quite liked how committees were operated and how the committees were populated, getting outside expertise, how that was separated from council committees as well. So they seemed to quite like that. Oscar was even quite liking the fact that ALEOs seemed to actually be pushing the boundaries of what charities could do in a good way. They were surprised in a good way about what some of these organisations were doing. Oscar is, and in their latest update on their key risk areas, they have 6 of them. One of them is novel or unusual structures, particularly around groups. ALEOs do tend to have a group structure to them with some form of trading company in there. They sometimes have community interest companies. KICs, for me, KICs are just weird. I don't know why. I quite often say to people, when I'm looking at a new ALEO group and say, why have you got a KIC? Don't know. And I say, I don't know why you'd have one either. Very odd things. They have the word community in them. So their branding is fantastic. They have created the word community, and therefore people have thought, that's for us. Beyond that, I don't know why someone would probably want one. You can probably get the characteristics of a KIC from other things. You get a weird regulator with a KIC, you get a weird set of articles with a KIC, they're generally just a bit weird. So on the whole, they're weird. So there are ways in which you can create that trading side in other ways, either sometimes through the charity itself. Charities can be as commercial as you like, so long as the purposes are drafted correctly, and if you want to do things that are out with the charity's direct purposes, why not just have a normal company limited by shares, which is wholly owned by the charity? That creates an asset lock in its own right. If you want to stick the word community in the name of it, that's cool, and you avoid having the difficulties that go along with having a KIC. One thing that Oscar gets very interested in, that we're interested in the ALEO report, is conflict management and kind of the reality of the dynamic. What is actually happening in practice about how an ALEO is working, how it is appropriately controlled in terms of accountability for the local authority, whilst at the same time being suitably independent. And for existing ALEOs, dealing with the conflict side of things is important. I think it's worthwhile just having a quick canter through the conflict of interest rules. I think they're quite interesting. I think they also have mythology behind them as well. So where do you find some of the conflict of interest rules? Well, in the governing documents of the ALEO itself, whether it's a company, a scheme, if it's a trust, that's even worse than a KIC. So if you've got any trust out, you can put trust in the name, but if it's a real trust, awful, bad place to be. In the personal and family world in which I sometimes inhabit, trusts are lovely. In the charities world I inhabit, trusts are an anathema. So if you've got trusts, do something about it usually. But most ALEOs are going to be companies, and we'll have an Articles of Association, which is where we will find, we hope, conflict of interest rules. There may be, in contractual arrangements, code of conduct, councillors' code of conduct, there will be conflict of interest provisions in there. The Companies Act will give us some stuff on conflict of interest. And importantly, the 2005 Act that deals with charities appears to give us conflict rules, and that is very important for ALEOs. The 2005 Act it has provisions around conflicts of interest, but they only kick in for certain trustees. And interestingly, again, I have a very low threshold in what is interesting, for ALEOs, you may have certain trustees governed by one set of conflict rules and other trustees governed by a different set of rules, which can make for an interesting dynamic, and also just interesting in saying what rules actually govern this charity. So the fundamentals of being a charity trustee found in the 2005 Act, section 66, if that's where you want to go and look at it, says act in good faith. We would hope everyone was doing that. You are acting consistent with the purposes of the charity. So whatever the constitutionally stated purposes of that charity are, follow and further them. That's high-level stuff. Once you're getting into the operational stuff, acting with care and diligence, which you would expect when you are looking after somebody else. I always think this is the Monica bump test. Monica in Friends looking after Ross's baby. She bumps it off the wall, has to give it back, and the baby continues to say, Monica bump, and he tries to understand what that was all about. And I think if you're looking after your own children, they're a bit more malleable, they're a bit more droppable and stuff. When you have other people's children, you want to be able to deliver them back after the play date pristine. Well, that's what charity law is about. It's not your own children, so you have to take a bit more care to pass it on to the next trustees, or to be looking after these assets and services for the public. So you have to be a bit more careful than you would be yourself. So that is the fundamentals. And then it goes on to say you've got to take account of other duties that you have, be good to employees, sort out health and safety, all that kind of stuff. And there's also a bit that sort of underlines that it's about collective, and I was about to say cabinet responsibility. I don't know if cabinet responsibility means the same now as when I started speaking, but you've got to act as a group, and therefore if one trustee is going a bit off-piste, then you need to rein them in, so you're working as a group, and Section 66 is encouraging that to happen. So these are the fundamental duties. It then introduces what appear to be conflict of interest rules. So it says where there's conflict of interest, then you might have to choose between putting the interests of the charity first, and if you're unable to do that, so if there's an irreconcilable conflict, then you stop participating in that decision and voting, etc. But the 2005 Act applies that conflict rule only in a situation where there is a conflict between the trustee and somebody who has appointed them to be a trustee. It's not a general rule. So if you have a charity where some of the trustees or all of the trustees are just appointed by the other trustees, this rule does not apply. If you have an ALEO where some trustees are appointed by the trustee group, this rule does not apply to them. However, if you have trustees who are actually appointed by the members, by a local authority, then this rule does apply. So you can end up with two different sets of conflict rules working at the same time for ALEO trustees, and that can be very important to remember. If there is a more difficult decision to be made, then it is important that if trustees are being reminded of their conflict of interest rules, that people recognise that there might be slightly different rules applying to different trustees. Because if this rule doesn't apply, and the Articles of Association don't set out a sort of uniform set of rules for all of the trustees, then you are just going back to the fundamentals of the 2005 Act, which is acting in the interests of the charity and its purposes, acting with care and diligence. Some trustees may have to think about conflicts between themselves and who is appointing them, but if that doesn't apply to them, then it is just they have to put the interests of the charity first. That is their conflict rule, unless, of course, there is something in the Articles of Association that says something differently. And, of course, it's not just about being seen to deal with conflicts of interest, but it's about is there really a conflict, but also how it looks, and therefore in any conflict management procedures, codes of conduct, is reminding people of how might this look to the world. So there may be situations in which people do not want to be actively involved in a decision because it may appear to taint the decision, or if they are going to continue with something whereby they may have some kind of involvement or knowledge or something, then they have to make it very clear, and it has to be very clearly documented, that they recognise that they have to be putting the interests of the charity first and that they are demonstrably doing that. So always remembering other duties and acting collectively. And this is not a brand new slide for me, and I've ended it with collective duties, because I think if things are going to go wrong in any charitable organisation, it is going to be when the understanding of collective responsibility starts to fall apart. If that falls apart, all bets are off, and it's going to be a bit of an exciting showdown. But if people remember that they are making a board decision, they've got to act collectively, and that when they go out the room, they don't start complaining to the world about a decision that was taken. There was a board decision, but certainly I don't agree with it. Might not be the best way to create unity, and collective decision making is very important. That has been emphasised this week. So breaking news. Other people have been interested in Brexit. I have been interested in #Trustees Week. And the beginning of Trustees Week was a gift, as we had the Scottish Governance Code for the Third Sector was launched. It had been consulted upon for during the latter part of the summer. And one of the bits that jumped out for me, and in a lovely blog about the draft, I was waxing lyrical about how great it was that collective responsibility was highly featuring in that, and in the final version it is there. So collective responsibility is a really, really important thing, and the governance code, which has just come out this week, it is very good reading for anyone involved with a charity, very good reading for ALEO trustees, because this is going to be the base standards that people are probably going to test good governance by in Scotland. And I also think because it's got the word code in it, people are going to be almost called to account on it. And there's going to be people saying, you've breached the code. I can see there being that moment where somebody is shouting across a trustee meeting at somebody else saying, you've breached this code, you're a bad trustee, even though it's really just about, indicative guidance for people. But it's going to take on that status, I think. But collective cabinet responsibility, very important. I won't go through it now, but its base pillars are these: organisational purpose, leadership, board behaviour, control. In the consultation response, I said that should be controls rather than control. When you then start reading what control means, they then start talking about controls. And I think that is perhaps important in the ALEO world, because that then starts to go into accountability, transparency side of things, that there are appropriate controls on how funds are used, activities provided and services delivered. So it's worthwhile reading. It's short as well, which is always good. I'm taking this slightly out of chronological order, but it sits alongside the ALEO discussion that Oscar had, is when Audit Scotland, the Accounts Commission, looked at things. And they broke down their report into the use of ALEOs, again noting it's very wide, and also noting lots of different legal structures in there. Again, breaking it down from there's not just such a thing as an ALEO, all sorts of different legal vehicles can be used. Naturally, for Audit Scotland Accounts Commission, a section on oversight, controls, accountability, transparency, pulling out a number of achievements that they say that if it hadn't been done through an ALEO, it might not have been as good as it actually was. So saying, there are real benefits to using an ALEO structure of whatever legal structure it may be, and looked to the future. Their highlights in the future include they can be good things, not without risk, and we need to be thinking about changes to rates relief for new ALEOs that are coming along, which takes us really, I think, into the Barclays review. It was a kind of an unexpected gift for the charity geek, because there were certain bits that were obviously about charities in the Barclays review, but charities were peppered all over the place in it. So a lot of charity stuff going on in there, definitely not just about ALEOs. So all charities really need to recognise that the Barclays review could have an impact on whether or not they get rates relief, and also sports organisations as well. A lot said about them. Ken Barclay, probably not the biggest fan of ALEOs, I would say, from reading that report, perhaps, saying that there should be a stop to abuse. There had to be a level playing field created. So I said one of the reasons why ALEOs appeared in the scene in the first place was to create a level playing field, and now people are saying let's remove one of their benefits to create a level playing field. So that I thought was quite an interesting turn of phrase, noting that there were tax avoidance, which is quite strong, and again that there were avoidance tactics in relation to non-domestic relief, and ultimately the conclusion was that ALEOs should just lose their rates relief status, and that they should just be paying rates in the normal way. Scottish Government didn't accept that should be fully the case, and that there should just be a blanket removal of rates relief for ALEOs. The position being that future ALEO expansion, whatever that means, and we might see in the not too distant future what that really might mean, that is an area where rates relief wouldn't be available, but for existing services, existing ALEOs, then they should continue to be able to get the rates relief. And in terms of where the implementation really is now, well, programme for government in September said there will be a non-domestic rates bill, and that it will seek to ensure a level playing field and take away known avoidance measures, which would appear to be lexicon for new ALEOs would not qualify for rates relief. Alongside that, because the programme for government had, again, was an Alan Nichols gift, was saying there will be a review of the Charities Act to look at transparency and accountability. That's quite a wide phraseology, so anything could happen, and there, I understand there will be a consultation coming along, so stand by for that. Whether the opportunity is taken to, for example, say that certain segments of the charity sector should be treated differently or have different benefits attaching to them, like ALEOs, for example, who knows, but there could be a degree of interconnectedness between what is happening on the non-domestic rates bill and any review of the 2005 Act around the notion of what is a charity. Is an ALEO, is that a charity, I would say. If it's got charitable purposes and does charitable things, then yes, it is. But some may see that it is at the outer edges of what should be recognised as a charity. So stand by for some draft bill and a consultation on the 2005 Act. But if there is going to be changes to how ALEOs are recognised as a charity or recognised for rates relief purposes, one of the things is what on earth is an ALEO? How do you draft legislation that captures an ALEO when there's all sorts of things out there that you might look at and say, well, that's obviously an ALEO, and then someone else says, well, no, it's not. When you look at the list of ALEOs that Oscar looked at, you look at some of them and you say, if I spoke to somebody, as I have done, to somebody in that organisation and said, you work in an ALEO, they would say, no, I don't, definitely don't work in an ALEO. There are some organisations out there. There was one I was looking on the @Be Charitable Twitter account. So if you want to keep up to date with charity stuff, then follow that Twitter account. But I was looking down the media section of where you get the pictures and videos that you may have posted. And I looked at one picture that came up of a building, and I went, goodness, that is actually probably run by an ALEO. They would be taken aback if you said that you are actually an ALEO. So it's the characteristics and features of it that may mean it's an ALEO rather than any sort of particular legal thing. And also, there is no such thing as an ALEO. So maybe an ALEO is an elephant. Maybe that is the test. If it kind of looks and feels like an ALEO, it's an ALEO, and that's how we'll define it, rather than there being any neat, certainly legal structure definition to it. And maybe the future of ALEOs is going to the fact that they are flexible. Maybe we'll get rid of the word ALEO and some other cool term will come up that people will be making a myth of in the future, but it could be that flexibility, that it can be anything you want it to be if you are creating the right characteristics, features, and importantly, fitting in the governance and accountability, then that is your ALEO of the future. Because that focus on purposes and governance is going to be the key. Because if people are doing structures for anything, why are people creating a structure? Because you actually want certainty. If people have been delivering important services, museums, sports centres, social care, moving forward, city deal projects, whatever it is, why would someone want a structure? Because you actually want something that is a structure, something that is clear and sets out the governance, the accountability, the purposes of what this thing is going to deliver in terms of a project or a wider vision. So if there's going to be a future for ALEOs, it might not be with the word ALEO, because it's probably a bad word and a strange word and it means nothing. It's about legal structures that actually deliver purposes, governance and accountability. And if people are going to create things or have things that exist and are just wanting to make sure that they are, another horrible phrase, fit for purpose, but actually doing what you want them to do and actually work effectively, then I am always inspired by Dazzle camouflage. And I was down in Liverpool for the first time a couple of weeks ago, so I was, because I'm cool on my holiday, I was taking a picture of the Dazzle ship and then talking about charity law on it, because I was thinking, there's the real Dazzle ship. I love Dazzle camouflage. I am always inspired by Dazzle camouflage because it's designed to make it difficult to tell what this is. Is it a warship? Is it a merchant ship? Is it something else? What is it? So you don't know what it is, so that's bad. Also, I always find it very difficult to find where the bridge is. So where is the centre of command on this thing? So if your governance of anything you've got, ALEO or any structure, reminds you of Dazzle camouflage, then you probably need to have a look at it and try and make it clearer and more certain and make it obvious that you're either a warship, a merchant ship, or a nice little dinghy. You know, you want to make it clear what you are and be able to identify where is the bridge on that ship, so you know what is in charge of it. How effective is that camouflage? Somebody said to me, is that slide deliberately? Have you missed a slide? I said, it's the worst joke in the world. Fortunately, it's my only camouflage joke. And the other thing is, you know, it can be very exciting for lawyers to dream up very complicated structures, but always remember Heath Robinson. If you're going to come up with something, try and make it simple, because you can put all sorts of energy. Because the other thing is, particularly around things like conflicts of interest, and you know, what might the public think about how this organisation works? Let's just throw the kitchen sink at it. We'll have a 2,000-page induction pack for new trustees, because that will cover everything. We'll have a big code of conduct that size, and actually so much energy is put in to things that actually you achieve nothing. So actually a degree of keeping it simple, streamlined, actually could be quite effective. And certainly whatever an ALEO of the future or any legal structure is going to be, trying to keep it as relatively simple. Of course, it's magical and it's very difficult and complicated and all that. That's of course the case, but trying to actually make it streamlined to achieve whatever the purposes are, and that governance function and accountability ultimately is what we want to try and do, rather than having a Heath Robinson contraption. And that is everything from me.
This is your opportunity if you have any questions for Alan. It's Friday, so don't feel you have to confine yourself to the subject of ALEOs. I'm sure Alan would be delighted to answer any questions you have on the malleability of children, back catalogues of Friends, or movies starring Whitney Houston. An expert in all these fields.
Absolutely, if only I knew about the law.
Just why oh, sorry.
Why is the concept of ALEOs on the way out? Why is it not a bad word?
I think I don't think it's a bad word. I just think it means nothing to an extent. So rather than thinking it's an ALEO, it's a whatever it actually is, or here are the characteristics of a project. What legal structure makes that happen, rather than we have this project, it must be an ALEO. Where people might think certainly for new ones, and I suppose that's now with where we appear to be going with rates relief, is existing ALEOs, and that might actually create opportunities for existing ALEOs to in some cases be able to do more, because they might be the places that services are delivered from, because it's not going to be perhaps so attractive to set up new ones. Is if a new one is not going to be able to get rates relief, then that might hit the business case for doing it. And certainly behind what the Barclays review appears to be wanting to achieve, and the Accounts Commission Audit Scotland came after the Barclays review, was saying, if that is actually going to be what happens, then that is going to make it perhaps less attractive to set up new ones, because you don't have the rates relief attaching to it. But that doesn't mean existing ALEOs cannot continue, grow and develop. And I say there's nothing bad about the concept of an ALEO. It's just, in some ways, an ALEO is just a tag that has been attached to things, and maybe that tag has taken on a life of its own. Maybe if there hadn't been a tag that was as almost mystical, there's something magical about an ALEO. It's like this week it's been a bumper week for me. There's a consultation on the taxation of trusts that's come out, and actually UK government, HMRC, has actually started that paper by saying there's actually nothing that magical about trusts. People use them for very normal reasons, and maybe there isn't anything particularly special about the taxation of them. And in many ways, maybe the myth-busting of ALEOs is required. There's nothing particularly magical about the tag or the word ALEO. It's really about what they're actually trying to do, and getting back to that is going to be the important thing.
Does anyone have any other questions? Charles?
Just, it's more of a comment than a question, but just building on the earlier point about control and independence and a slightly different conflict angle, just important for councils when they're thinking about the use of ALEOs to balance the need for independence from charitable test purposes with the need for control for procurement purposes. So if councils are using ALEOs with a view to awarding contracts to them, there is a tension there if the ALEO is going to have charitable status compared to what it needs, how much control there needs to be for it to be exempt from the procurement rules. You may or may not have thoughts.
Well, I suppose my thoughts are that if someone says we're about to do something, let's have an ALEO, I first of all will say, don't say ALEO, it could be whatever we need. But then the next thing that pops into my head is, right, Alan, you know about charities, but you definitely don't know about procurement stuff. And we do not want to be setting off down a path of saying, right, these are the key characteristics of what our charity is going to look at, and these are things we need to think about in terms of board composition and membership of this organisation, and therefore how it gets its control, and then see that you torpedo some very important procurement side of it. So it is, for me, if someone is talking to about an ALEO structure, I'm thinking, let's go and talk to someone like Charles, because I don't know about procurement stuff, and we need to talk through that to then try and understand whether we need something totally different to be doing it, because we can't fit in with what Oscar would view as acceptable, or we can get the right balance. I would say in recent ALEOs that have been created, Oscar has been, I think, quite understanding of the reasonable degree of control that a local authority or other members of an ALEO would naturally want over that particular charity, and have been relatively relaxed in terms of board compositions. One thing that Oscar is usually interested in is that the chair of the organisation is an independent trustee. That is something they think is very important and see as an influential figure. But as Charles says, there can be competing interests here, and trying to blend them together is very important, or very early identifying if it is going to be impossible to do it through a charity, to take it down a different route before you embark on the wrong path.